Okay, so Bashan, I did go to HEB to try to get some breakfast for staff. And I said, "Where is the breakfast?" And guess what I was told?
What was that?
They said the person who bakes is out with RSV. I'm like, oh my gosh.
Oh, wow.
So they don't have anybody.
It is true, Judge. There are people that.
Are indispensable? Yeah.
Hope they feel better.
Oh gosh, yeah. I was like, all right, so Cheeseman, is that family violence or criminal trial division?
Hi, Judge. It is, I believe it's family violence. Good morning.
Good morning.
Doesn't show that it's coded family violence, but I would believe that offense is family violence.
All right, Norma, could you have someone from family violence come down?
She's here.
Hi. So this is Cheeseman. She's requesting a travel permit.
Yes, Your Honor. She did request that. However, we kind of had a misunderstanding. She was told, I think, by her PO that she could travel, and that was for yesterday. She's present in the courtroom, but she canceled her plans because then we got notice that there was a hearing today.
All right, so I received a request for a travel permit. And the state is saying that they object to your traveling. Have you traveled before?
No.
All right, so they're saying they object to your traveling. And what I can tell you, defense, I always present these travel permits to the state to see if they have objections. If they don't have objections, usually I will sign them with, conditions that I want to impose. But are you going to have to travel again at any point in time?
There's a possibility.
All right, so let's go ahead and hear this and see what's going on.
Yes, Your Honor. Can I just, Your Honor, can I just have a minute to finish on the protective order docket? I'm closing out with a DA right now, and then I can be back in a couple of minutes.
Well, what I can tell you is in a couple of minutes, we're going to do a motion to suppress, and then we're going into a jury trial.
Okay, I will be here. I'm here.
All right, thank you. So the court is calling NIMAC number 756623, State versus Tiana Cheeseman. Can I have parties announced for the record?
Ashley Jones for the state.
Terry Dye on behalf of Tiana Cheeseman.
And are you Ms. Cheeseman?
Yeah.
All right, so we're having a hearing with regards to the defendant's ability to travel. The court received a travel permit. The state was in objection to allowing the defendant to travel. I just have a few questions to ask you about the travel permit. Any objections to the court asking your client questions?
No, Your Honor.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Tiana Cheeseman.
All right, so with regards to your travel permit, what is the purpose of the travel?
It's a mental health conference. It's a postpartum support conference. This is from July 9th to July 13th, and it support postpartum mothers with their perinatal mental disorders and support.
Okay, and are there any other upcoming travel plans for you that you possibly see in the future?
There is one, I believe it's going to be in August.
Okay,
I'm not sure of the exact dates, but I think that's just going to be in Houston.
okay,
That far.
all right, thank you. And here's my question. How long has this case been open? What's the offense date?
Your Honor, just permit me 1 moment on the computer.
And defense,
Yes, Your Honor.
with regards to this case, was CPS involved?
They've closed out their case
All right, and can you tell me the placement of the child or children?
with my client.
All right. And those children are the subject of this alleged offense?
One child, yes, Your Honor.
All right. But all children are placed with her?
Yes, Your Honor.
And I think that's where part of the state's concern was, Your Honor, on the motion or on the travel request, it said there was a no contact order with the victim. And so that's partly why the state was concerned.
Well, we need to address that because obviously another court has deemed that she could have contact. I'm not the one who placed the orders in this case. So counsel, I'm inclined to grant her request to travel based upon what it's for, but this is what I'm going to need before I grant it.
Yes,
If
Your
you,
Honor.
if you can have the CPS worker or whoever it is, give to the state, the fact that the case is closed, to give to the court, you know, did she complete classes? What classes she completed? And if you
She
can
did,
let,
Your Honor.
and if you can let me know how long the children have been in her physical custody.
Okay.
All right, that's what I'll need, but I'm inclined to grant it and to lift the no contact order. Currently, if the child is with her, she's in violation of the no contact order, but I know sometimes people may not be aware that there's a no contact order in place with their children. They think that once the civil court says you can have contact, then they don't take into consideration what's happening in the criminal court. So, state, I don't know if you're going to file a violation report for her having contact, but
Your Honor, the other parent is in the house and there were provisions put in place.
well,
And I had discussed this previously with, I believe it was Allie Jackson who had the case a while back, and we had discussed that fully at that time.
all right, so here's the issue. The issue is legally, there's still in place a no contact order according to this. Now, if another judge signed a no harmful or injurious contact on the criminal side, then it needs to be documented to show that that's been signed. But before me now, I have where it says that there's a no contact order in place. What I can tell you, if the state files a request that there be a violation report filed because you have a no contact order, I'm not going to sign off on that until we have a hearing about it. So it will just be paperwork being presented.
Just for the state, Your Honor, we need to clarify if there is a no contact order.
Yes.
There was an amended motion, but it states with other children. So my understanding was that there was a no harmful or injurious contact order with the other children, but still a no contact order in place with the victim. At least that's what's reflected on the travel request.
Yes.
And so the state needs to verify that.
And Your Honor, we did appear before this court quite some time ago on the issue. My client works with children. She, you know, she's a nurse. We did have a hearing on this issue quite some time ago. But my understanding was that it was no harmful and injurious contact, including her own children, once she was deemed able to go back to the home.
Right. So this is what we're going to do. Okay. I want you to hear me and internalize what I'm saying.
Yes, Judge.
Number one, we need to make sure of what the orders say. If I receive a violation report saying that you've had contact with the complainant, we're going to have a hearing on it. I'm not going to act on it until we have a hearing, because obviously a civil judge has done something on the civil side. And sometimes the civil side and the criminal side don't talk as they should talk. So defense, if you can get me that information and get that state the information with regards to her CPS case.
Yes, Your Honor.
And then we can reset this for a hearing. And at that time, I'll address your ability to travel and we'll clear up with whatever issues this is with the no contact order, because I don't think you want to walk away and not, be in violation.
Yes,
So
Your Honor.
we're going to get that taken care of and see what's going on with it. Okay.
Yes.
All right. So when do you think you'll have that information, Ms. Dye, and when do you want this case recalled?
If we could recall it for sometime next week, that would be great if that works with everyone.
All right. And if you want to be here by Zoom, you can be here by Zoom, because it's just a
Thank you.
hearing on the travel permit
Okay.
and the whether or not you should be having contact. Okay. All right. What date, Ms. Ferguson?
The 16th, Your Honor, is the only date that I absolutely cannot.
All right, 17th,
Yes,
yes, and you can appear by Zoom.
thank you.
And I'll get like a message on how to.
Yes, and your attorney will have it as well. All right, thank
All
you.
right, thank you.
Thank you, Judge.
Thank you.
Thank you, Your Honor. Have a good day.
You too. It is. Who knew? But now I know. Hmm. In the words of G.I. Joe, that's half the battle. All right, we're going to go on the record in 2023 CR 10004, State versus Tyler Ashbaugh. Can I have parties announced, please?
Megan Galloway and Jason Garahan for the state.
Nathaniel Navy and William Salazar for Mr. Ashbaugh.
All right, and are you Mr. Ashbaugh?
Yes, ma'am.
All right. Just so attorneys know, you do not have to stand when you're addressing the court. It just makes it easy for the court reporter to hear. I don't take it as a sign of disrespect. I know in law school, we were taught to always stand, and it's a hard habit to break. It was for me on the civil side until the judge on the civil side said, I'm going to fine everybody every time you stand. So I was like, all right, let me hold on to my seat. All right, so this is a motion to suppress, correct?
Yes, Judge, there's a number of pretrial matters, probably more expeditious to take up the motion to suppress, but there's also a motion requesting the state to elect which paragraph in count 3 that they are going to rely upon.
Mhm.
But I can get into that argument later, and then various motions in limine.
All right. I don't have copies of the motions. Do you have extra copies, or if you don't, I can have the clerks pull them?
I don't think I have extra copies, Judge.
Because how many motions do you have?
I'm sorry,
How many motions?
the motion to suppress, and then the one on the indictment, and then 2 motions in limine, Judge.
All right, so I have defense first motion in limine and defendant's motion to suppress.
Okay. The one that's first motion in limine might be the first supplemental. There's just a motion in limine that was filed before that.
Okay, let me see if there's anything else in the file. No, I don't have any of your other motions. If you could let the clerk know what the motions are, or if you could make copies.
I can make copies. The only thing is some of them are marked up.
Okay.
But I can get with the clerk. Judge.
State, do you have copies of his motion?
I have a copy of the motion to suppress, but that's it, Judge.
All right,
I'm hoping that the people.
all right, we're gonna see if we can pull those. What am I doing? What do you want? What's the lead from? I have no idea what you're talking about.
But when you accept the check as, copy that it's all
Sure.
written on, and that's his original, and it wasn't filed, so
All right,
I think
so,
I'll copy of the original.
yes, yes.
And then this is the final copy.
I just wanted.
I'll be right back. Okay.
I'll get my stuff. Yes.
All right, thank you. All right, so then I have a motion to suppress. I have the first supplemental motion in limine. And the defense request for election. All right, so the motion to suppress,
You also have just the regular motion in limine, Judge.
all right. All right, so here's the thing. On the regular motion in limine, what is that specifically concerning? Because I don't have a copy of it.
Okay.
Oh, you can remain seated. Yeah,
It's such a habit.
I know.
Please don't find me like that. I've been-
no.
So. The points in this, Judge, are any extraneous criminal arrests or misconduct. I believe those would be highly prejudicial and appropriate to limit this case to whether or not these alleged allegations occurred. Any of that could highly prejudice the jury against my client. And then there was discussion in his statement to Detective Tudor about Tyler engaging in drug distribution. That is not relevant to the case at all. There's no allegation that this involved drug dealing in any sort of way. It was more brought up when Tyler and Detective Tudor were discussing his finances and what he was doing to make ends meet. And so that would be highly prejudicial, Judge, if the jury were to hear that. I don't think it's probative at all to these allegations.
So your motion in limine is to request a motion in limine as it relates to extraneous offenses or conduct?
Yes, both of those, and then also to either mute or delete that portion of the statement if the state intends to offer that, of the statement that Detective Tudor took from Tyler, so that the jury does not hear that part. Then we have, I would request just that the state, when Tyler is charged in front of the jury, not read the enhancement paragraph, as that only relates to punishment.
Oh, they're not gonna read the enhancement paragraph.
And then, also, we don't know if this is gonna happen yet, Judge. We haven't made a decision, but if Tyler were to testify, he would not be able to be impeached with his juvenile adjudication. There's a specific rule in the rules of evidence that states it's not considered a criminal conviction or a felony conviction for purposes of impeachment. And the only purpose that it can be used in an adult criminal case is for purposes of enhancement after a conviction. It is not in any way considered a felony conviction. So if that were to happen, I would request that they obviously not mention it or not attempt to impeach him with that adjudication. Not even considered a conviction, it's just a juvenile adjudication. And then the last thing, Judge, is one of these search warrants, not for the real-time search, not for the real-time cell site information, but it was for his historic cell site information. You were the judge that actually reviewed that and signed that. I just request that that not be entered into evidence, as I don't want any juror misinterpreting that as a comment on the weight of the evidence from the court.
You mean the fact that I signed it?
Yes, Judge.
All right.
I'm just asking that it just, if they want to say a judge, but not not be entered into evidence or not mention that the judge of this court signed this search warrant.
All right. So state, with regards to the motion, the defense motion in limine, I do see and understand the defense's argument that they would not want the jury to know that I'm the judge that signed the search warrant. So, you want to address that? As far as my signature being mentioned, or that it was this judge that signed that?
Well, just regarding that, I mean, they are specifically charged in the charge of the court that they are not to take any comment from the judge as giving weight to any evidence. And so that would just be my argument, that they're charged on that. I mean,
So are you intending on offering the actual warrant into evidence?
I don't have a yes or no, possibly. So I
Alright.
guess, I mean, at this point, regarding point one, the extraneous criminal arrest, I mean, I agree. If I believe that it becomes relevant at some point, I will approach the court and make my argument regarding that. Regarding point two, that's extraneous. I'll have a copy with that stuff redacted out and tender to defense for inspection prior to offering it. And then if I believe that that becomes relevant, I will approach before listening in testimony. Regarding point three, the enhancement paragraph, I agree to that. I would not read it for guilt innocence. And then point four is just the same thing about the criminal history 404.
All right, so with regards to any extraneous or conduct, if you feel that you're going to ask any questions or elicit any evidence to that, you all will need to approach and we can have a hearing outside the presence of the jury. I don't know anything about this case, so I don't know if it's relevant or not. I don't know if it should be admitted or not until I hear certain things. With regards to the warrant issue, if you are seeking to enter the warrant into evidence with my signature on it, then I'll address that issue at that time on whether or not it should be entered before the jury with my signature, or it should be stated that I'm the judge who signed it. So I'll address that at that time. All right. Does anyone want to address the next motion in limine is your spousal privilege motion? Or is there another?
Please give me a second to pull that up. Okay, so at the time that this allegation came about, Tyler, his girlfriend, Tatiana Martinez Escobar, they were dating, they were living together, they had a child together. Since then, they got married, they have a second child together, Judge. The state has subpoenaed Miss Martinez, Tyler's wife. Under Texas Rule of Evidence 504, the spousal testimony privilege, not the immunity, but the spousal testimony privilege. A spouse, and it does not matter when they were married, it doesn't matter if the marriage happened after the alleged offense, before, whenever it happened. It's just a rule that the state cannot call the spouse of an individual as a witness for the state. And there's no exception to that. There's a number of exceptions listed in that rule, but there is no applicable exception under Rule 504, Judge. And so this rule is, I believe, very clear cut. That the state just cannot call her as a witness for the state. Now, if she's not called for as a witness for the state, I would also argue that if they tried to address any statements she made, whether that would be, there was a typed statement in this case from her, it's not recorded or anything like that, but it's a typed statement, that would be hearsay.
But, according to the rule, the person who claims the privilege is not your client. It would be the spouse who made the communication, correct?
Well, correct, but I don't believe it's not. It is the spouse, but it's the rule takes into account the spouse of the accused.
But now it clearly states under 504 who may claim the privilege. The privilege may be claimed by the communicating spouse. So in this instance, I'm assuming you're stating that the communicating spouse is his wife.
Correct, Judge.
So it's not his privilege to claim, it would be the wife's privilege to complain, to claim.
No, yes, I misunderstand. Yes, you're exactly right on that. It is my understanding that she intends to claim that privilege.
Well, we'll cross that bridge when we come to it.
And I would just, part of that motion in limine is that if the state wants to call her as a witness, despite knowing this rule, I would ask that that be done outside the presence of the jury. Courts have ruled that it is, that is actually reversible error to call her as a witness in front of the jury and then have her invoke the privilege in front of the jury. That's prejudicial and that would be a reversible error.
Well, here's the thing. Number one, she hasn't invoked spousal privilege. Number two, there are other steps into 504 under that rule that have not been met at this point in time. So there are different steps. One, whatever communication was, what was the communication? Number two, was that communication intended to be private by the person who's communicating it? So those are all steps that have to be gone through. And unless, somebody's going to testify and say, this is who these communications were made to. They were intended to be private, and this is how it was intended to be private. But my understanding of the case law is if there's a communication between spouses and it's not intended to be private, i.e., they're not the only person who is communicating the information to their spouse, they've communicated to the mother-in-law or whoever it may be, then 504 does not apply.
And Judge, I would disagree. There's two things. There's the spousal immunity, which I believe the court's referring to, and then there's the spousal privilege.
No, this is privilege. A communication is confidential if a person makes it privately to the person's spouse and does not intend its disclosure to any other person. A person has privilege to refuse the disclosure and to prevent any other person from disclosing a confidential communication made to the person's spouse while they are married. This privilege survives the termination of the marriage. So if the communication is not intended to be confidential, then the spousal privilege doesn't apply. For example, if Jane Doe were married to John Doe and they communicate something to them, and then that same communication that they communicated to their husband, they communicated to a third party, then that's not confidential. It's similar to if you have discussions with your client, that's confidential. But then if your client goes and discuss that with other people, then it's not confidential because the privilege, in this case, the privilege belongs to your client's spouse and the person who is communicating whatever they're communicating.
And Judge, if I could just differentiate, I believe that 504, there's two parts. There's 504A, which is the confidential communication privilege. And I believe that's what the court is stating survives if the marriage ended and she wanted to testify, that's where Tyler could claim this was intended to be private and bar that as long as there were no exceptions from being entered into evidence. We are relying on 504B, privilege to not testify in a criminal case, where it says the general rule is in a criminal case, an accused spouse has a privilege not to be called to testify for the state.
And who may claim the privilege? The privilege not to testify may be claimed by the accused spouse, not by the accused. So you need to have whoever the communication is supposed to be from, that person needs to come in and claim privilege, and they probably need an attorney. So does that person have an attorney?
That person does not have an attorney, Judge.
Does that person need an attorney appointed?
I have no reason to believe that person needs an attorney. I don't think there's any allegation that the state believes there's any criminal activity that was
I have no idea.
that was
Yeah,
committed by this person. So I do not believe she needs an attorney.
regarding her testimony, it's not anything that she could be charged with, to my
Okay.
knowledge.
And so obviously, I don't know who the state is going to call.
All
All I
right,
know is that-
everybody is using terms of I believe and to my knowledge. So it's up to whoever the witness is. If that witness feels they need an attorney, they can't afford an attorney, the court will have an attorney appointed to them. Now, so with regards to that, I'll need to hear from that witness whether or not they're claiming privilege. So let's move on to the motion to suppress.
And then Judge, I'm sorry, just
Sure.
one last point on that. If we are waiting to make a decision on that, I would request that the state refrain from mentioning any statements made by that spouse, because the court hasn't ruled on this,
Statements made by the spouse when?
any of the statements made by the
No,
spouse.
I mean, when are you objecting to them presenting that?
In opening and at any time before she testifies.
All right, so with,
And I would argue she cannot testify, but for the state, but if they are attempting to, and the court rules against me, I would object to them mentioning any statement she made, whether that's text or the type statement, at opening or at any point before they attempt to call her as their own witness.
all right, with regards to opening statements, the court is not going to allow the defense to preclude the state from making their opening statements. Opening statements are not evidence. Parties are required, although I see some people don't do it, parties are required to let the jury know this is what we expect the evidence to show. And if the evidence doesn't show what they expect it to show, then it doesn't show it. All right, let's move on to the motion to suppress.
Okay.
And counsel, what are you seeking to suppress?
Give me 1 second to get to that, Judge. So we are seeking to suppress the fruits of the search of Tyler's apartment complex and his statement given to Detective Tudor.
Okay. So the search of the apartment complex. And when you say the search of the apartment complex, do you mean his specific apartment?
Only his specific unit, Judge, yes.
All right. So the search of his apartment.
Yes. And everything that was discovered and seized as part of that.
All right. And then also you say the statement.
Yes, his statement, his reported statement to Detective Tudor that was taken immediately thereafter, where he was arrested and taken to Bear County downtown to give that statement. Judge.
All right. And was this done under warrant or not?
There was no warrant. No, there was. So how they discovered Tyler's location was they tracked his cell phone in real time without a warrant. And so our arguments is there's 2 reasons why this was illegal.
No. I mean, I just want to know what are you seeking to suppress, and then we can call witnesses, or you can call witnesses and we'll see where we go.
I understand, Judge.
All right. And state, do you stipulate that there was no warrant?
Regarding the phone pinging, yes, I stipulate that there was no warrant.
All right. And are the witnesses here?
Yes, no.
All right. Who's the first witness?
And Judge, I believe that because it's warrantless, the burden shifts to the state now.
All right.
It's on the state.
Yes, I mean, it does.
Okay.
All right.
The state calls Chad Tudor.
Good morning. All right, do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand and have a seat. There should be a square microphone. If you could put that on your lapel or somewhere, it's for the court reporter to hear.
This way.
Yes. And just remember to take it off before you leave.
Oh, yeah.
All
I
right.
forget.
All right, if you'll state your name for the record.
Good morning. My name is Detective Chad, CHAD Tudor. T is in Tango, U, D is in Delta, OR.
All right, you may proceed.
Good morning, Detective Tudor. How are you currently employed?
I'm assigned to the San Antonio Police Department Homicide Unit.
And, are you a certified peace officer?
Yes,
How long have you been with the San Antonio Police Department?
14 years.
And then how long have you been with the homicide unit specifically?
The last 4 years.
What are your duties as a detective with the homicide unit?
I'm currently assigned to the murder detail. So I investigate suspicious deaths, suicides, accidental deaths, overdoses, homicides, and even officer-involved shootings.
Okay. Back in June of 2022, were you assigned to the homicide unit?
Yes, I was assigned to the aggravated assault detail.
Okay, and under the aggravated assault detail, were your duties to investigate the same offenses?
It was different. It was misdemeanors, including assault bodily injury. And then I also had felonies, including aggravated assaults with deadly weapon. And in this particular case, I was asked to investigate this officer-involved shooting.
Okay. Do you recall the SAPD case number associated with this case?
I do not.
Did you write a report that reflected your investigation at the time that you were conducting your investigation?
Yes.
And would it help you to refresh your memory if you have a copy of that?
Yes.
So I'm showing you, is that an accurate, a fair and accurate copy of your report?
Yes.
And was that authored by you?
Yes.
Okay, and just know that you can use it to refresh your memory, but please don't read from it. Okay?
Yes.
Okay, so what is the SAPD case number associated with this investigation?
It's SAPD 22108-229.
Now, do you recall how you were assigned to this investigation?
I was told the details of this incident when I arrived at the headquarters that morning. My duty hours that day were 7:45 to 17:45, and I was briefed on the details of this incident because it happened in the early morning hours while I was at home.
Okay. And so the incident occurred prior to your duty hours, is that correct?
Yes.
Okay, so when you arrive at the homicide office, you're briefed as to details, is that correct?
Yes.
All right, and so there had been some investigation conducted prior to your involvement, is that correct?
Correct.
All right, and so at the time that you received the case, were you starting to develop a suspect?
Yes, fairly quickly. The details were that officers were parked at a church, working on reports. A white SUV drove through the parking lot, and the officers reported that the vehicle shot at them. One of the officers was able to exit from his vehicle and return fire. I was told that patrol officers were in the area and located a vehicle in a neighborhood not far from the church. And they made contact with an elderly person that was there that said, you know, my son or stepson or grandson, I can't remember the relation. Tyler has been driving this vehicle. And that's kind of where, you know, I kind of took off with everything.
Okay. And so after you received that suspect information, there were other reports in the database that linked the defendant to the car and the home, is that fair to say?
I believe so.
And when I say the home, I mean the location at Buckmore.
Can you repeat that part? I'm sorry.
So when I said linking the defendant to that home, I was referring to the Buckmore location where the elderly man was, is that correct?
I believe there were reports I can't remember. Can I look through here real quick just to see if I notated that?
Yes, go ahead.
I'm not finding anything right now.
Okay, I'll just move on from that question. So once you received the suspect information, what were the next steps? Well, I guess let me know that. When you received the case, you spoke with somebody by the name of Joseph Gonzalez, is that correct? If you want to flip to page 4, please.
So Joseph Gonzalez.
Yes, at 10:37 hours, he was.
You said paid for?
Page 4 at 10:47 hours.
I don't.
Sean.
Okay, yes, at 10:47 hours, I called phone number 210-854-6117. This number was given to me by Joseph Gonzalez, parent of Tyler Ashbaugh. And Joseph told me this phone number was a phone number for Tatiana. Tatiana's father's phone number. Tatiana was in a relationship with Tyler.
Okay, and so were you able to make contact with someone at that 210-854-6117 phone number?
Yes.
Do you recall who you made contact with at that phone number?
The father of Tatiana, and his name is Daniel Martinez Escobar.
Okay. Were you equipped with a body worn camera at the time that this conversation took place?
Yes.
Okay. All right, I'm showing you what has been marked as State's Exhibit R1. Can you tell me what that is?
It's a copy of my body worn camera.
And how do you recognize it?
I've initialed it and put my name or my initial CT and badge 2841.
And have you previously reviewed it?
Yes.
And is it a fair and accurate depiction of the events as they occurred, when they occurred?
Yes.
This time, tendering defense for inspection and offering states R1.
No objection.
And what is the state's exhibit number, please? R1? All right, then state's exhibit R1 is admitted for purposes of this hearing.
Permission to publish, Your Honor.
Granted.
My name is Detective Tudor with the Sampson Police Homicide Unit. I was trying to reach a Mr. Ashbaugh. Hi, sir. I got your phone number, in regards to an active investigation that I'm on. I'm trying to locate an individual named Tyler Ashbaugh.
Okay. Oh my God.
And so, I was given information that you are, Tatiana's, dad.
That is correct.
Yes, so it's nothing right now that, involving her, I don't believe.
Oh my God.
Okay.
Chairman.
Yeah, no, I'm not trying, I wanted to just come out and say, it's nothing right now with her, but he was, we believe, involved in an incident last night. And I'm trying to find him and, yeah, that's how I got your phone number because of this. There was an officer involved shooting.
Oh God. Oh, are you serious?
Yes.
Oh my God. They got a child together, man. Come on.
Yeah.
The heck is wrong with these kids, man?
So Daniel, so what I'm trying to do is just, I'm trying to make sure that, she's okay. I don't believe, I don't even have enough to know that if she was with him when this happened. I don't, there's just a lot of info that I don't know. But I do believe that he was possibly involved in this. And it was over off O'Connor Road.
Oh,
Do you have any
what
idea?
else can you tell me about this? I mean, it can't be that she was with him. Come on.
I don't know. I don't know anything. I'm trying to find him.
You're trying to find him.
Mm-hmm.
Shoot, out of my mind, I can't tell you the areas. I know how to get there.
Well, I know that, I guess they have an apartment somewhere like Oak Valley.
Correct.
Okay.
Okay, so I'm pausing the state's exhibit at this point in your conversation with Mr. Martinez Escobar. He confirmed that the defendant was living at the Oak Valley Apartments, is that correct?
Yes. Do you have a good phone number for her?
Yes.
I
I
have
do.
854-6005. If there's a way you can confirm that.
Hang on. What number do you have?
854-6005.
Yeah, that's her number.
Okay.
Are you okay?
That's what I'm trying to figure out. Like, I'm trying to, one, make sure Tyler's not hurt.
Okay, where did this happen and why?
That's what I'm trying to figure. That's what I'm trying to figure out. Officers are sitting in a parking lot and start getting shot at. And then we find this vehicle with bullet holes, busted out windows, and it's parked over at Tyler's grandpa's house. Over off Buckmore.
I don't believe it's his grandpa. I believe it's like his stepdad.
Okay, yeah, it's one of those relatives.
Yeah, it's
So, yeah, and so I'm trying to make sure, one, Tyler's okay, and that, this, nothing else is
I
gonna
have to
happen.
call my daughter.
Yeah, I need to find her because I don't know how
I need to
he's,
call her right now.
Can you-
She's got my granddaughter.
okay, when was the last time you spoke to her?
And my wife, I think, spoke to her yesterday.
Okay, this all happened like 2 this morning.
Oh, what is this kid involved?
Yeah, and I'm just trying to make sure that.
Part of the shooting is it?
That's what I'm trying to figure out. I mean, there's a car that, that grandpa or whatever, we don't know that relation, stepdad or whatever, said that Tyler's been driving this car for the past week. So, I don't know where Tyler is. I've got a car with bullet holes on it and officers, telling their side of the story.
Okay.
So, I don't know if, was she in this car with him? Is she okay?
I need to call her.
Yeah, can you get my, write down my information and call me right back?
Can you hold on the line? I'll call her.
Yeah, absolutely. Absolutely. And then Daniel? I was trying to call, that's trying to call. You didn't know anything about it? Just let them, so yeah, I just figured. They'll make sure she's on there. She was in this. Do you have the appointment number? What? Well, I just, I think there's detectives over there right now. I do understand. Can you call them? Can you call them? Can you? I need to figure out what the apartment number is. Can you try and call her first? I just did. What did it do? It did quite straight to voicemail. The phone is all for the phone is out there. Does she have a vehicle? No, she does not. How does she typically get around? Usually either I go pick her up or I'll pick her up. I bring over. Does she work or? She's staying at home with the baby. Okay, the grandfather, step grandfather, he gave Sonia Esteban, I guess your wife's info too. So that made contact with you, I guess, is she there too, or does she know? She's at work. Okay. And she might know the apartment number. Do you want me to call her? Yeah, I can stay on hold. Okay. He's gonna call his wife to confirm the apartment number. But he's wanting to go over there. She's not answering, but also straight to voicemail. He's worried about her. Do they know the?
Okay, so at this point, while he has confirmed the apartment complex, has he been able to confirm an apartment number?
No.
And did you advise him that you believed detectives were already at that apartment complex in general?
Yes. Yeah, something. Oak Valley. Oak Valley apartments.
Okay, and pausing the state exhibit, what are you currently doing on your phone?
I think I was trying to verify an address for Oak Valley, so I was doing like a Google search, I believe.
Okay, and I guess, did you ever make the location of the Oak Valley apartments, or did you send a different unit out there?
No, so the person that I'm talking to, kind of like having a sidebar with in the vehicle, is a sergeant. He's actually my current sergeant on the murder detail as well, Sergeant Marfin. So he was on the phone, kind of helping me out, relaying information to detectives with our covert unit, plainclothes detectives that were actively looking for Tyler.
Okay, thank you.
Yeah, Oak Valley, 12607. Yeah, he's pretty good. He's kind of pretty good. He's going to take the voicemail. I got the right pay with issues. There, Mr. Ashbaugh.
Hello?
Mr. Yo, you still there?
Hello?
Yes, sir. Cameron?
Okay, she doesn't know the apartment number either.
Okay, it should be.
Now, there's officers there, there's a compactor. Across from the compactor, the first building on the right. There's a hallway. It's the first apartment on the left.
Okay, it should be.
Okay, and so at this point, did Mr. Martinez Escobar give you specific instructions as to where the location is?
Yes, he's describing the apartment location.
Okay, and so I guess, do you recall what floor he said that the apartment was located on?
I believe he said first.
Okay, and he said that it was across from the compactor, is that correct?
Yes. 607 Judson. I think that's what it is.
Oh. I can't believe it. I know how to get there, but I don't talk to you because I'm sorry.
No, you're fine. You're fine. Do you have a?
To get on over there, I want to make sure that my daughter's okay.
Yeah, I do understand your concern as a parent. I'm a parent as well.
That my wife wasn't about to clock out and go over there. I told her not to.
Yeah, because I think there's plainclothes detectives over there trying to do some surveillance. And I just don't know where he is, what kind of mindset Tyler's in.
Okay.
I just
Is that car there?
No, we have the car. We have the white SUV.
Okay. Alright, well, I'll keep trying to call my daughter. It's a good number.
Yes. Well, I don't know what pops up on it. Can you have a pen? I'll give you. I'll give you all my info.
No, just this wireless caller. Give me a second.
Yeah.
I'm feeling like throwing up.
No, I know.
Because my granddaughter is with her.
Is there anybody else any other family that they, where she might be, or do you have any any other information that might help me find?
It'd be there or here.
I gotcha. Okay.
Okay, what's your number, sir?
Yes. So my name is Detective Tudor. T is in Tango, U, D is in Delta, O-R. And my phone is 210. This is my. 21037, and I'll give you my. And my badge number is 2841. Yeah, I mean, there's more questions than answers right now, and I'm just trying to,
I just want to make sure that my granddaughter and my daughter are okay, so
Sure.
if you hear anything, could you please let me know?
Yeah, absolutely. And if you guys hear anything, can you
You need me to stay awake.
please let me know.
I can't go over there.
No, I would stay away from that location for now. Continue to try to reach out to her.
Okay, it's my wife, hang on.
Okay.
What's up?
And the person that we just saw walking on the right side of the vehicle, is that Sergeant Marvin?
Yes.
There.
Who's they? Both of them? Who's telling you this?
Wife is telling me that Tatiana just called her back now.
What is
This wouldn't be a prank or anything like that.
sir? No, this is not. I can give you the case number. I'm not.
I believe you. I mean, I'm seeing your phone number on where it's just.
Okay. What did Tatiana?
Supposedly enter in the apartment and my daughter said that she didn't see anybody out there.
What did Tatiana tell your wife specifically?
Okay, you want me to call her back?
Is this the 85, is she 854-6118?
Correct.
Okay, let me
It's
call her.
very anxious to
Yeah.
go over there.
No, let me call her real quick.
Same reason, so.
Let me call her real quick.
Okay.
All right, thank you, sir. Hey, Mr. Escobar, what's a date of birth for you?
Not the date of birth of who?
For you.
02/04/1960.
60. Okay, I appreciate my call, Senator, real quick.
Yes.
Okay, and so up until this point, Mr. Martinez de Escobar made contact with his wife, is that your understanding?
Yes,
Okay, and so what he's relayed to you at this point is that both the defendant and Tatiana Martinez Escobar were in the apartment at the Oak Valley location, is that correct?
yes.
Hello?
Hi, Ms. Escobar. This is Detective Suter with the San Antonio Police Department.
Yes, sir.
Sorry to startle you and Daniel. I'm trying to locate a Tyler Ashbaugh and make sure he's okay. And then I don't know if Tatiana was with him early this morning when all this happened. It's a shooting that I'm investigating. But I'm trying to there's a lot more questions than answers right now. Is Tatiana saying that she's over there off Oakview or at Judson at the apartment?
Yes,
What's the apartment number?
I don't know the apartment number, I was trying to get in.
Did she say who was with her?
No, she said Tyler and the baby are there,
She said Tyler and the baby?
are there with them,
Okay. Okay.
And it,
Okay, and so the female that you're speaking with at this point, who is that?
The Daniel Escobar's wife, and it should be Tatiana's mom, Sonia.
Okay, and who did she tell you that was inside of the apartment?
She said that Tatiana, Tyler, and their baby were all at their apartment.
Okay.
Do you know their
you know, I asked her if she was okay. And she said, why? I said, well, because supposedly something happened over there at the dad's house. You know, my older, I mean, that's. Everything my husband told me, so.
She told you, she said Tyler is right there at that office.
Yes.
Do you know the apartment number?
I don't know.
Okay, let me call you right back. She said she just spoke to her, she's at the apartment and I was in there. Rachel, it's on Judson. No one knows the apartment number.
They know what they said they figured it out because he's on the video.
Okay, and so what did Sergeant Marvin just tell you right then?
He's telling me that they figured it out. When he's saying they, I know he's talking about the covert detectives. And he
Yep.
said that something about a water bill.
That the defendant was on a water bill at the location, correct?
Yes.
Okay.
He's saying the baby's in there. It's a 2 or 3 year old. And that Tyler's in there. And she's like, what's going on? She's like, she doesn't know. Just got Okay.
Okay, do you know who Sergeant Marvin was relaying this information to?
I don't know if it was in direct contact with one of the covert detectives or the covert supervisor.
Okay,
It was someone with covert.
all right, and then eventually the defendant is taken into custody. Were you able to conduct an interview with him?
Yes.
And was this interview recorded?
Yes.
Okay. I'm showing you what's been marked as State's Exhibit R2. Do you recognize that?
Yes.
What is it?
This is an initial copy by myself of the interview, the recorded interview with Tyler Ashbaugh.
Okay. And have you reviewed it?
Yes.
Is it a fair and accurate depiction of the events as they occurred on the date?
Yes.
And was this interview conducted while the defendant was in custody?
Yes, he was arrested on a traffic ticket warrant.
Okay, and did you read him his rights in compliance with 3822 of the Texas Code of Procedure, Criminal Procedure.
Yes, at 13:58 hours, I read Tyler his Miranda rights and he acknowledged that he understood his rights.
I'm tendering to defense for inspection and offering State's Exhibit R2.
No objections.
All right, State's Exhibit R2 is admitted for purposes of this hearing.
Permission to publish, Your Honor.
Granted.
Yes, sir. Very good.
I'm Detective Tudor. You all right?
Okay, yeah.
This is that you might have to go to the bathroom or something.
Yeah, let's get this done first.
I'm looking, there's two sides to every story, so I'm trying to figure out, I was asleep, at 2 a.m. when all this apparently happened, right? So I'm trying to figure out what happened. Before I talk to you, I have to read your rights, okay? Before you're asking any questions, it is my duty as a police officer to advise you of your rights and to warn you of the consequences of waiving these rights. You have the right to remain silent. You do not have to make any statement, oral or written, to anyone. Any statement that you make will be used in evidence against you in a court of law or at your trial. You have a right to have a lawyer present to advise you before and during any questioning by police officers or attorneys representing the state. You may have your own lawyer present, or if you're unable to employ a lawyer, the court will appoint a lawyer for you free of charge now or any other time. If you decide to talk with anyone, you can, and you can stop talking to them anytime you want. The above rights are continuing rights, which can be yours by you at any stage of the proceedings. Do you understand these rights?
Yes, sir.
Before,
Okay, and so what we just saw on Exhibit R2 is you reading the statutory warnings to the defendant and him acknowledging them and waiving them, agreeing to speak with you. Is that correct?
correct.
We passed the witness one.
All right, just give me 2 minutes.
Of course, Judge.
Proceed with your questioning.
Yes, Judge.
All right, you may proceed.
Good morning, Detective Tudor.
Good morning.
As you stated, you were assigned as the lead detective to investigate what you described as an officer involved shooting, correct?
Yes,
Okay. And this took, you stated that you believed that officers were fired upon by an individual, correct?
yes,
Okay. And through your investigation, you identified a possible suspect as Tyler Ashbaugh.
yes,
And what we were seeing in this video is you were attempting to locate Tyler, correct?
the prior video, yes,
Yes, sir.
yes,
Okay, you were trying to locate Tyler. You did not know exactly where he was at the beginning, correct?
no, I was trying to find him.
Okay. And you spoke with Tyler's father, correct?
Yes,
Okay, Joseph Gonzalez.
yes,
And he was unable to provide you where Tyler could have been, correct?
Yes, he made confirmation by a name of the Oak Valley. He never provided me with an apartment number or address.
Okay, so he could not provide you with an apartment number, correct?
Correct.
Okay, just the name Oak Valley Apartments. And he was able to provide you though with Tyler's girlfriend's father's number, Daniel.
Yes,
Okay. And we saw you speaking with Daniel Escobar.
correct.
And in that video, we saw that Daniel was also not able to provide you with the specific apartment number that Tyler was in. Is that correct?
Correct.
I think he confirmed that it was also Oak Valley, but didn't know the unit number, correct?
That's correct.
Okay. And in your report, you state that when you were talking to Daniel, you did not have enough information to know what happened, correct?
Correct. It was a very active
Okay.
investigation.
And he told you that Tyler lives with Tyler's daughter and Tatiana.
Yes.
Daniel's
Yes.
daughter.
Yes.
But as we stated, Daniel didn't know the exact apartment number.
Correct.
Correct. And so Daniel called his wife Sonia in an effort to provide you with more information, correct?
Yes.
Okay. He was trying to be helpful in your investigation.
Yes.
And after he called her, they were still only able to provide the apartment complex and not the unit number, correct?
Yes.
Okay.
They were pretty much providing the same info, and then one kind of described the trash bin and first floor, but they relatively the same information.
Okay. Did you speak with Sonia?
Yes.
Okay. And in your conversation with Sonia, she was also not able to provide you with the unit number.
Correct.
Okay. And then at some point, you state that you informed the covert detectives of the information you've been given, but at that point, they already told you that they've already located the apartment number.
Yes, and this is all getting relayed to me through my sergeant that's talking with them.
I understand. So at this time, you are trying to relay everything that you know, which is the unit and possibly some directions, but not an apartment number, correct?
Correct.
And when you do that, you are informed that we've already located the unit number.
Yes, I put at 11:03, and he said, I think they figured it out. And then at 11:08, I was told that they had a visual of Tyler opening the door to the apartment.
Okay. And you would agree with me that in your report, there's no mention of a water bill being used to locate Tyler's apartment, correct?
No.
Okay. And you're aware that other detectives state that they were able to locate Tyler through his real-time cell phone tracking.
Sorry, I don't understand that question.
Are you aware that other detectives state that the reason that they were able to locate Tyler was through his real-time cell site data information?
I don't recall that those specific details.
Did anybody inform you of that, or you just not recall?
I don't recall.
Okay. And did you know that that was done without a warrant?
I don't recall.
Okay, so you had no involvement in real-time cell site location information.
Correct.
Okay. And detectives shortly thereafter confirming that they find the apartment unit that Tyler is in, take him into custody.
Yes.
Okay.
I notated 12:06 while I was canvassing for video. I was notified that Tyler was in custody on the active municipal court traffic warrant.
Okay. So he was taken into custody for a traffic warrant.
Correct.
There was no arrest warrant for aggravated assault on a public servant at that time.
No,
There was no warrant for deadly conduct with a firearm at that time.
no,
Okay. It was just because he had an existing traffic warrant that he was arrested and taken in.
yes. And obviously come down to hopefully find out more about this incident.
Okay, so he was arrested on the traffic warrant with the hopes that you would find out more about this incident.
Correct.
Fair to say it wasn't because you guys were interested in this traffic warrants, right?
No, it's that he had an arrest warrant, so that's a way to bring him to headquarters and see if he'll talk.
It was a way to get to the point of talking with him without having that arrest warrant for that specific offense yet
Correct.
of aggravated assault with a public servant or deadly conduct.
Correct.
Okay. And after he's arrested, he is immediately taken to SAPD headquarters so that you can talk to him, correct?
Immediately, I'm not sure. It was shortly after that. I think it was 1 o'clock was when I started talking to him. And he was in custody a little after 12, so fairly quickly.
Fair to say that was the next place he went,
Correct.
was to SAPD headquarters right after he's arrested.
Correct.
And that was the next phase of the investigation, was to get a statement, correct?
Correct.
There wasn't anything that happened between the statement and his arrest. It was part of an investigation into Tyler.
No, when he was brought down, while he was being brought down, we were also executing a search warrant for the apartment.
I understand, but I guess I mean in relation to just Tyler. There was nothing taken from him. There was no swabs or DNA done. The next thing that happened to Tyler after he's arrested was you talking to him at headquarters, correct?
Yes.
Okay. About the witness.
No further questions.
All right, thank you. You may step down. Leave the microphone.
Thank you.
And if you'll leave the exhibit with the court reporter, please.
Yes. RARFIN. It was in November. Sorry.
All right, next witness, please.
The state calls Joe Rios.
Look this one over. And then after, is this the last witness?
There's 2 more, Judge.
Okay,
I don't think they should last very long, Judge.
all right. And then after this happens, I'll make a ruling on your spousal privilege. No. No, this is all I have. All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, thank you. You can have a seat. If you put that square microphone on your lapel or somewhere, it's for the court reporter to hear. And if you'll state your name for the record.
Joe Heriberto Rios.
All right, state, you may proceed.
Detective Rios, how are you currently employed?
I'm a investigator with the Texas Board of Criminal Justice, Office of the Inspector General.
Are you a certified peace officer?
I am
How long have you been a certified peace officer?
since 1999, approximately 26 years.
Okay. Did you previously work for the San Antonio Police Department?
I did from December of 2000 through September of 2023.
Okay. And in the year 2022, did you work with the San Antonio Police Department?
Yes, I was assigned to the rapid response team in the repeat offender program.
Okay, and as a detective with that unit, what was your duties?
Our primary task in the rapid response unit was to locate violent fugitive offenders.
Okay. Do you recall the SAPD case number associated with the call or the call that we're here for today?
Yes, ma'am.
Do you recall the SAPD number?
Oh, the case, no, I can't, sorry.
Okay, did you write a report at the time of your investigation?
I did.
Would it help you refresh your memory if you were able to have a copy of that?
Yes.
Can you take a look at that for me?
Okay.
Does that appear to be a report?
Yes, it's the supplement report I wrote on the date.
And it's authored by you,
Yes, it is.
and you recognize it to be true and accurate?
Yes.
Okay, so you can use it to refresh your memory, just please don't read it.
Yes.
So what was the SAPD case number associated with the call?
The SAPD case number SAPD 22108229.
Okay. And do you recall how you were enlisted to help in this investigation?
Yes, ma'am. My lieutenant at the time, Justin Good, called me up on the weekend. I was one of the lead investigators. A unit was newly created around that time. Was one of the senior guys in the unit. He called me up, said they had an incident involving a couple of SAPD officers that had been shot at. They had some information on a suspect and they needed help locating him.
Okay. And so did you have suspect information at that time?
Yes.
Do you recall who this suspect's name was?
The name I was given was Tyler Ashbaugh. I don't know if I'm saying that correctly, the last name.
Okay. And so can you walk us through some steps that you took to conduct your investigation and learn the location of the defendant?
At the time they were getting information, the vehicle had already been recovered. Different officers or detectives, I'm not sure, things were getting added to the call. Well, we call it the key card, but the incident detail report. There was a previously known vehicle that he had been ticketed in the year prior. There was a cell phone that a number that was provided that was supposed to be his. During the conversation I had with the lieutenant, I told them because of what had transpired, the officers returning fire, the suspect still being at large, that there was exigency to go up on the phone to locate him, whether for the safety of other officers or the general public, or if he had been shot during the course of the exchange, he needed medical attention.
Okay. And so regarding, I guess let's start with the vehicle information that you obtained from the key. What did you do with that information?
That information was put into a system called Vigilant. It's a license plate reader system. All that does, it uses, there's different tow truck companies or private companies that do vehicle recoveries, whether it's for apartment complexes or car dealerships. These different, you'll kind of see them riding around on the tow trucks. They look like little square or rectangle lights. They read license plates in and around an area, so San Antonio. The license plate that he was ticketed in the year prior had popped up at an apartment complex 74 times. So that was likely a location that he resided at or stayed at frequently.
Okay. I'm gonna show you what's been marked as State's Exhibit P3. Can you take a look at that for me?
Yes, this is the Vigilant analysis report that was returned back on the vehicle.
Okay, and you're the one that received that, is that correct?
Yes,
Okay, and it's a fair and accurate depiction of the information that you received?
yes, it is.
Okay, and that was used in your investigation, is that correct?
Yes, it was.
Tendering to defense for inspection at this time, offering State's Exhibit P3.
No objection.
And what is the exhibit number?
P3, Judge.
All right, P3 is admitted without objection for purposes of this hearing.
Permission to publish, Your Honor.
Granted.
All right, can you see that up there, detectives?
Yes, I can.
Okay. If you have trouble, you can turn around and look at the big screen. But I guess, so what was the license plate that was entered into the system?
The license plate was N as in Nancy, Y as in Yankee, X as in X-ray, 3837.
Okay, and that's the same license plate that was obtained from the plea card, is that correct?
Yes, it was.
And if we take a look down here in the location summary, can you please explain that first line and what that means?
Yes, so this analysis report gets put together and gives you likely locations of that vehicle. And the most popular, the way it's worded, most popular sighting location was 1206 Judson Road, San Antonio, Texas, 78233. Last LPR, which is license plate reader or reading, was 5/20 of 2022. And it was seen at that location 74 times.
Okay. And do you recall what time you received this information?
Approximately 9:40 in the morning.
Okay. And then one second. Okay, and then you said that you came into knowledge that the defendant regarding the phone number that the defendant was associated with, is that correct?
Yes.
Okay, and so then did you obtain a search warrant to ping the phone or no?
When I was speaking with the lieutenant, at that time, I didn't have, there's certain officers that can claim exigency. They have to go to specific classes. I'm able to obtain regular phone warrants. Exigent warrants are a little bit different. So I told the lieutenant there was enough to go exigent. I don't know who actually did the warrant or when it was obtained. I started receiving emails. They put me on the return. Like I said, I can't recall who did the warrant at the time, or if there was a warrant or a phone call was made to do the exigency, but I started receiving emails at about 9:48 that morning.
Okay, and so with the exigency, what were the circumstances that led you to believe that you could do an exigent circumstances search on the phone?
The unprovoked attack of the officers, the offender got away, so if he was looking for, if the person was looking for other targets to go after, first responders or the general public, or because of the exchange of gunfire, that the suspect needed medical attention.
So I'm showing you what's been marked as P4. Can you take a look at that and tell me if you recognize that?
Yes, these are the emails from AT&T on the updates that we were receiving at the time for the phone.
Okay, and you're the one that received that information, is that correct?
Yes,
And is it a fair and accurate depiction of the information that you received?
yes.
Okay, I'm gonna show you P5 was previously entered into evidence as P3, but this has an additional page. Can you just confirm whether this is a fair and accurate copy of, or what it is, and if it's a fair and accurate copy?
Yes, it is. It's the same license, from the vigilant plate search, location analysis report that I received via email.
Okay, and then I'm gonna show you P6. Do you recognize what that is?
It's an aerial, of the, it's the overhead, of the apartment complex, the
Okay.
surrounding area.
Okay, you're familiar with what's depicted in State's Exhibit number 6, P6?
Yes,
Okay, and it's a fair and accurate copy.
yes, it is.
At this time, the state offers, while tendering to defense for inspection, P5 through P6 inclusive, and offering the same.
No objections.
All right, P4, 5, and 6 are admitted for purposes of this hearing.
Permission to publish, Your Honor.
Granted.
Okay, Detective Rios, so I'm gonna start with P5, which was previously entered as P3. And so you've confirmed, just for the record, it's the same record, however, what is this that I'm displaying in addition to what was offered and entered in P3?
It was an email I received from, Deputy U.S. Marshal Stephen Caballero
Okay, and at what time did you receive that?
at 9:40 a.m.
Okay. And I'm going to publish State's Exhibit P4. If we can take a look at that. Can you tell me what we're looking at here?
That's the return for the exit and file number, for the device that was, for the exigency. And that return was, timestamped at 9:48.
Okay. And have you previously done pings for phone prior to this, using exigent circumstances?
I'm not sure how to answer that, only because when I was on the Marshall Task Force before, I was covered under TUI. So I don't know if any of that is.
Okay, I'll just move on. I guess at your time with SAPD, have you previously pinged phones?
Again, I was assigned to the U.S. Marshal Task Force previously from July of 2017 through May of 2018, or I'm sorry, I was full-time from July of 2017 through May of 2018. And then I was part-time until 2020. So there's investigative techniques that I'm not allowed to testify to.
All right, moving on. If you could take a look at State's Exhibit P6, what were the latitude and longitude associated with the Oak Valley Apartments?
The lat and longitude numbers,
Yes,
you want to read them out?
yes.
Okay, sorry. 293314.19 north. Well, I'm sorry, 29 degrees, 3314.19 north, 98 degrees, 2136.4 west.
Okay. In this case, now I'm going to publish P4. And just at what time did you receive State Exhibit P4?
At 9:48.
And so that would be after you received the information on the plate reader, is that correct?
Yes, ma'am.
All right. And just, can you explain to the court how the pinging works? Does it give you a specific location, or what is the area that's covered when you receive that information?
Different returns come back, usually they're spread apart every 15 minutes unless there's need for almost live tracking. In this case, every time there was an update, we would get information. Sometimes it would be 122 meters, sometimes it would be 600, 700 meters. So every return would come back with a different, what we call a margin of error. So there was, I don't believe there was anything under 100 meters that I can recall.
Okay, And so if we take a look at State's Exhibit P4, starting on the first page, what time did you receive that at?
That one came in, at 9:50 AM.
Okay, and the latitude, longitude that is on, this page, is that the latitude, longitude of the apartment complex in P6?
No, it's not.
Okay. Moving on. What time did you receive this information?
That one's at the same time. I think that's the same.
Okay, moving to the first page, what time is that?
That one's at 9:50.
Second page, what time is that?
I'm sorry, 9:52.
Okay,
Sorry.
is the latitude and longitude associated with the Oak Valley Apartments?
No, it is not.
Moving on to the next page, what time did you receive that?
At 10:08 AM.
And is that latitude, longitude associated with the Oak Valley Apartments?
No, it is not.
Moving on to the next page. What time did you receive that communication?
10:23.
Is that latitude and longitude associated with the Oak Valley Apartments?
No, it's not.
Next page, what time did you receive that communication?
That one's also 10:38, or I'm sorry, 10:38.
Is that latitude, longitude associated with the Oak Valley Apartments?
No, it's not.
Next page, what time did you receive that communication?
10:40.
Is that latitude, longitude associated with the Oak Valley Apartments?
No, it is not.
Next page, what time did you receive that communication?
10:55.
Is that latitude or longitude associated with the apartment complex?
No, it's not.
Next page, what time did you receive that communication?
11:10.
Is that associated with the apartment complex?
No, it is not.
Next page, what time did you receive that communication?
At 11:25.
Is that latitude, longitude associated with the apartment complex?
No, it's not.
Next page, what time did you receive the communication?
11:40.
Is that latitude, longitude associated with the apartment complex?
No, it's not.
Next page, what time did you receive that communication?
At 12:10.
And is that latitude, longitude associated with the location?
No, it's not.
Next page, what time did you receive that communication?
At 12:41.
Is that latitude, longitude associated with the apartment complex?
No, it is not.
Next page, what time did you receive that communication?
12:56.
And is that latitude or longitude associated with the apartment complex?
No, it's not.
Next page, what time did you receive that communication?
At 1:11.
Is that latitude, longitude associated with the location?
No, it is not.
Next page, what time did you receive that communication?
At 1:26.
Is the latitude, longitude associated with the apartment complex?
No, it is not.
Next page, what time did you receive that communication?
1:41.
Is that latitude or longitude associated with the apartment complex?
No, it's not.
Next page, what time did you receive that communication?
1:56.
Is that latitude, longitude associated with the apartment complex?
No, it is not.
Next page, what time did you receive that communication?
2:11.
Is that latitude or longitude associated with the apartment complex?
No, it's not.
Next page, what time did you receive that communication?
At 2:27.
Is that latitude, longitude associated with the apartment complex?
No, it is not.
Next page, what time did you receive that communication?
At 2:42.
And is that latitude, longitude associated with the apartment complex?
No, it is not.
Next page, what time did you receive that communication?
2:57.
Is that latitude or longitude associated with the apartment complex?
It is not.
Next page, what time did you receive that communication?
3:12.
Is is that latitude, longitude associated with the apartment complex?
No, it's not.
Next page, what time did you receive that communication?
327.
Is that latitude or longitude associated with the apartment complex?
No, it's not.
Next page, what time did you receive that communication?
342.
Is that latitude or longitude associated with the apartment complex?
It is not.
Next page, what time did you receive that communication?
357.
Is that latitude or longitude associated with the apartment complex?
It is not.
Next page, what time did you receive that communication?
And 412.
And is that latitude, longitude associated with the apartment complex?
It is not.
And finally, what time did you receive that communication?
428.
Is that latitude or longitude associated with the apartment complex?
It is not.
Regarding the information that I just questioned you on containment safety at C4, were any of those locations associated with the defendant's apartment specifically?
No.
Would a phone ping be able to provide you that information as to a specific apartment number associated with someone?
No.
Okay, and because when you receive the phone pings, what is it giving you? Is it giving you a specific location or an area?
In this case, it was only giving us, I believe one of the returns I saw a 99-meter margin of error. So that's a football field. In the past, I've seen them down to 7 or 8 meters, but dealing with apartment complexes, you have units that are stacked on top of each other. So it will never give you a true exact location.
Okay. And in your report, if you can take a look at it, towards the end, it says the tracking information led us to the listed location where covert surveillance was established. So when you're referring to tracking information, what are you referring to?
I'm referring to the way we got there through the vigilant records. Once we were at the location, the only thing that the phone provided was an area. But tracking included the vehicle tracking as well as the phone tracking.
Okay, but we established that the phone tracking didn't put you at the
Oh, I'm
call.
sorry.
Is that correct?
Yes, specifically for that apartment, the vehicle tracking led us there.
Okay. And what is covert surveillance?
Clandestine surveillance. We use the unit I was in at the time. We use regular civilian looking vehicles. We monitor giving information. We relay information to marked units. So we lay in wait and we either look for individuals that we're looking for or call out threats for approaching officers.
Okay. Do you recall who else you were working with on that day?
That day, I believe Detective Matt Robles, John Helly, Jason Reno, or Detective Jason Reno. Those are who I could recall that were actually out there with us.
Okay. Do you recall where you were situated when the surveillance was occurring?
I was, I would say on the south side of the building. When you come into the apartment complex, the building is almost immediately to you come in and there's a building facing parallel near a trash compactor or like a dumpster. It was right to the right of that. So I parked behind the building under one of the carports.
Okay. And so did you have direct eyes on the apartment complex or no?
Not on the door, or the doors were facing breezeways, so I couldn't see any doors.
Okay. Did the defendant eventually exit the apartment complex?
He did.
Okay. Was he taken into custody at that time?
Yes, he was.
Okay. And to your knowledge, was a search warrant obtained for the location?
Yes.
Okay. We pass the witness.
You may proceed.
Thank you, Judge. And I'm sorry, I didn't catch your title. Was it detective?
Well, the new agency I'm at is Sergeant Investigator, but Joe's fine.
No, that's all right. I'll just call you sir. So sir, you were assigned to assist in locating a possible suspect in this case, correct?
Yes, sir.
That was more or less the extent of your involvement in this case, was
Yes, sir.
locating the suspect.
Yes, sir.
Okay. And you wrote a report in this case, correct?
Yes, sir.
And in your report, you state through field interviews and investigative research, a phone number associated with the defendant was developed, that was in his possession, correct?
Yes, sir.
Okay. Were these your field interviews?
No, those were the cumulative effort of patrolmen on the streets, detectives.
Okay. And in your report, you state that that you conducted emergency tracking of Tyler Ashbaugh's phone, correct?
Yes, sir.
Okay. And you were the one that initiated that, correct?
I'm not sure who did. I know I was receiving the emails, but like I said, I know I told the lieutenant we had exigency.
And when you state that you were receiving the emails, the emails were addressed to you that contained all the vigilant license plate reader information,
Oh, no,
correct?
sir. I'm sorry, you're talking about the vehicle or the phone? There's two different things going on there.
Okay. Let's start with the license plate.
Okay.
That was still addressed to you, correct?
Yes, sir.
Okay. And in the state's exhibit that was entered regarding the the real-time phone location data,
Yes, sir.
those are also all addressed to you, correct?
Yes, sir.
Okay. Now, you stated after a question to the state that there was an exigent warrant that was obtained. Is that correct?
No, I said, okay, as far as, are we talking about the phone or the car? Because the car, there was no exigency on the car. There's no warrant required. Vehicles are driving around in a public area. So the license plate reader systems that we get access to take pictures in public areas. So there's, so.
And I understand that, sir. It was a poorly worded question. I mean, in regard to the phone records.
Yes, sir.
Okay.
There was the phone, so whenever there's exigency on a phone, there's not an order obtained immediately, correct? There's supposed to be obtained within 48 hours. In this case, I don't know who did the follow-up exigent warrant. I just know that there was exigency for the threat to the public or to help the individual get, at the time, they weren't sure if they hit him or not.
Okay. Were you the one that applied for the phone records?
I was receiving the phone records.
But were you the one that applied to get the phone records?
I'm not, like I said, I can't recall when everything was happening, whose name was put on the request on.
Okay. And you would agree with me that out of all the exhibits that the state entered, there was no warrant entered in any of those exhibits, correct?
No, sir.
Okay. There was
I'm sorry, yes, I would agree with you, yes.
You would agree with me. Okay, fair enough. There was no, I assume that there is some sort of permission process that needs to take place or some sort of application with the phone carrier before they approve real-time phone tracking, correct?
I know some phone companies operate off a phone call, some want a fax, some want an email. There's just different, each carrier is different.
But each one has some sort of application process. In other words, you can't just decide, well, I want the real-time records on this phone number without permission, correct?
Yes, sir. Like I said, I don't know that's at a dispatch level process. There's times that people call 911, phone hangs up. They go up exigent on the phone, or there's suicidal persons that call in, and then dispatch calls somebody, and then within 2 or 3 minutes, officers start getting information. So some of those happen fairly quickly.
But you would agree with me that there's some sort of permission required that can be either accepted or denied by
Yes,
the
sir.
phone carrier before they give you the real-time data, correct?
Yes.
Where the phone company can actually accept and give you this data as they did in this case, correct?
Yes, sir.
Or they can deny it, correct?
I've never experienced them saying no. So like I said, I don't know.
Okay, you've never experienced them saying no, but it's not just an automatic, correct? You need the permission from the phone carrier.
Yes, sir.
Correct. And out of the exhibits that the state entered, there was no paperwork or application for these records, correct?
No, sir, not that I saw, no, sir.
It's only documents of you receiving this location data.
Yes, sir.
Okay, and only you receiving this license plate reader information, correct?
Yes, sir.
Okay. So did you fill out the paperwork, or you don't know if you filled out paperwork?
I know I didn't, I'm not sure who filled out the paperwork.
Okay,
And just to, if I may, the only reason I'm not sure is because my emails were recovered. I had already left the agency when these records were obtained, so I'm not sure how much was recovered from my emails.
okay. And so if we don't have that today, we don't know.
Exactly.
Okay. And so when the tracking was approved, you had access to Tyler's real-time cell site location information, correct?
Yes, but I had already received the location for the vehicle information came in 8 minutes prior, and we were on the way to that apartment complex already.
Okay. And in your report, you would agree with me that you don't mention anything about license plate reader information.
No, sir.
You don't mention vigilant at all, correct?
No, sir.
And you would agree with me that you have extensive law enforcement training.
Yes, sir.
You're trained to write accurate reports
Yes, sir.
and include all the relevant details.
Yes, sir.
And in this report, you do not state that license plate records are what helped you determine Tyler's location, correct?
Not in this report, no, sir.
Okay. In this report, you state that you conducted emergency tracking of Tyler's phone, P1's phone, correct?
I said it was determined, I could just. Yeah, it says it was determined to conduct tracking, yes, sir, of the phone.
Okay. And there's nowhere else in this report that it says tracking of anything else, correct?
No, sir.
And then 2 sentences later, the report states the tracking information led us to the listed location where covert surveillance was established, correct?
Yes, sir.
And the listed location in this report is 12607 Judson Road, apartment 1101, San Antonio, Texas, 78233, correct?
Yes, sir. This report was written after when we arrested him and had the apartment number, so it's gonna auto-populate whatever the arrest location ended up being. So it didn't take me specifically to that apartment number, just the apartment complex.
And you went over all the locations of the pings with the state, just no friends.
And specifically for that apartment, just off the top of my head, we were nowhere near 600 or 700 meters with the phone information. The vehicle license plate return put us at that apartment complex.
Would you agree with me that there were 27 pings sent to you with his location information?
There was a lot. I'm not sure the exact number, but
Okay, there was a lot, more than 10?
you said with exact?
Yeah.
No, sir, 100 and, I think 100 and, the closest meter hit was 99 meters, which is a football field.
And if I may approach with that. Okay. And sir, if you could just count the time, the phone pings and let us know how many phone pings occurred.
Second, let me just go back real quick.
All right, off the record for a moment. Counsel, do you know how many pings it was?
By my count, 27, but
All right, you
I
want to
can't
ask,
testify.
you want to ask him if it was 27 pings?
I
He's
did
on
judge,
cross.
he wasn't sure.
All right.
One, two, four. There's 27 total, yes, and there was only 11 from the time that we got the records till he was in custody.
I understand. So after he was in custody, his phone was continued,
It was on.
pinging of his
It was
phone.
on.
How did that end? Did somebody have to say, hey, we're done, or does it just end at a certain point?
No, somebody would have had to notify the carrier.
And also in your report, you state that Tyler Ashbaugh was taken into custody for a municipal court warrant, correct?
Yes, sir.
Right. Pass witness.
All right, any further questions?
No, Your Honor.
All right, thank you. If you'll be sure to leave the microphone. All right, so just so both parties know, I've let the jury be excused till 1:30. And we're gonna take a brief break. Let me take up, Mr. Chumley, let me take up your case. And is your client Mr. Guillory?
Yes, sir.
Right, thank you. Cindy, Mr. Guillory, come down. Cindy, are you okay to switch over? All right,
Know if he's got. I could show you, it's just 10 months.
Oh, he's not.
Yeah, he's doing work upstairs.
All right, go ahead.
Yeah,
Go ahead.
Yeah.
Judge, can Tyler use the restroom?
sure.
sorry.
But the jury just left, so if one of you all want to take him with you. All right, the court is calling 2025 CR 006498 State versus Ronald Guillory. Can I have parties announced?
I'd like Chumley for the defendant.
And are you Mr. Guillory? Counsel, have you received all discovery? Did you review it with your client?
I have your.
Court will find that the state is in compliance with discovery. Mr. Guillory, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive reading of the indictment?
I do.
All right, state, it appears that you're proceeding on the indictment as presented, correct?
Yes.
Counsel, I'm sorry, Mr. Guillory, did you review the court admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
You're charged with theft under $2,500 with 2 or more convictions as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Guillory, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 10 months in the state jail facility. There are no applications and there's to be no contact with the complaining witness. In this case, the complaining witness is Walmart. Did you understand that to be the plea? Defense, is that the plea?
Yes.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that were filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No, Your Honor.
Then to the offencer's charge, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor. No objection.
Or state, you may be excused. Mr. Guillory, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client?
Yes, Your Honor, I've discussed his situation with his sentence. He's got 88 days approximately. And I told him to request, when he gets to the jail facility, the 2-for-1 option that's available.
All right, Mr. Guillory, you're gonna have to stop stealing. How old are you?
56.
All right, so 56, number one, going to prison and being in prison and then being at the Bexar County Jail, it ages you. So while other people are aging normally, when you are at the jail or the prison, every day is probably like 10 days of aging, right? So why are you continuing to steal?
I was on drugs, but I recently church program. I was in the process of getting in there again.
All right, do you have any family support? Do you have any family here in San Antonio? What part of Louisiana? All right, so maybe you need to go back to Lake Charles because you're going to need some support. What type of drugs had you been using?
Marijuana, alcohol.
All right. So what the court is going to do, I'm going to follow your agreement, sentence you to 10 months in the state jail facility, give you credit for any time served. There's to be no contact with Walmart. I'm going to recommend the therapeutic community. The therapeutic community doesn't increase the time that you're in custody. It's just to help you with your sobriety. You understand? I don't have jurisdiction to force them to place you in the program, so you'll have to ask for it as well. But when they review my judgment, they'll see that I'm requesting the therapeutic community for you. It's to help you with your drug addiction, and they will most likely, they're supposed to, I say most likely, but they're supposed to help you transition from the state jail facility to the outside world by giving you contact information to help you maintain your sobriety. All right, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. When you're released from custody, if for some reason you can't find a place to help you maintain your sobriety, if I'm still here, you can come back here. I'll pick up the phone, try to call somebody to help you or help you find housing. But you're going to have to make some changes. And alcohol, my understanding, I'm not a medical doctor, but it damages the liver and other organs. All right, good luck to you, okay? And don't make alcohol at the jail or at the state jail facility. All right. You're welcome. Cindy, do you need a short break?
Yeah.
All right, so you can take a short break. All right, everyone, we're going to take a 5-minute break so the court reporter can take a break, and we will be right back. And counsel, with regards to spousal privilege, I want this issue addressed with the court. And it's underprivileged not to testify, because that's where you wanted me to go. It says the exceptions. This privilege does not apply to A, certain criminal proceedings, in which the spouse is charged with a crime against the other spouse, bigamy, and then they have section B in bold print, matters that occurred before the marriage, if the spouse is called to testify about matters that occurred before the marriage. So if it's the court's understanding of the law, and you all can do your research, that if there were conversations that were had with his spouse before they were married, then that's an exception to the privilege not to testify in a criminal case. And if y'all both want to look at it, it's Rule 504. B. B. And it's the last section under B. And it's entitled Matters That Occurred Before the Marriage. All right, so we'll take a short recess. You have any questions about anything? All right, thank you. All right, State, you can call your next witness.
The state called Detective Matt Robles.
We're missing,
Okay, sure. All right, but could you go ahead and just have him on the stand?
Yes,
recently appointed to Judge.
Okay.
Recently.
All right. Oh, I see what the charge is. Give me a 30-day reset.
I can do, April,
Mhm.
August 11th.
All
I
right.
just saw Charles.
All right. Hi, Charles. So in this case, my understanding, I see that you were sort of recently appointed. So we are setting it for discovery August 11th. Is that good for you?
August 11th, yes, that's
All
good
right.
for me.
All right. And do you know what discovery is outstanding?
I don't yet.
Okay. All right. We'll set it for August 11th and your client has already been sent back. Did you need to speak
No,
with him?
I'll talk to him on the Zoom.
All right.
Okay, all
Thank
right,
you.
thank you, Judge.
You're welcome.
Robles.
All right. State, call your next witness.
The state calls Detective Matt Robles.
All right. Could you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right. You can lower your hand if you'll state your name for the record, please.
My name is Detective Matt Robles.
All right. State, you may proceed.
Detective Robles, how are you currently employed?
I'm currently employed with the City of San Antonio Police Department, and I'm assigned to the covert response unit.
Are you a certified peace officer?
Yes, ma'am.
How long have you been with the San Antonio Police Department?
16 years.
And I guess what are your duties as a detective with the covert unit?
Currently, I'm assigned with the covert unit, and my duties are to conduct surveillance. We seek out wanted fugitive individuals and narcotics investigations.
Okay. Back in May of 2022, were you assigned to the covert unit?
Yes,
Do you recall the SCPD case number associated with the call that we're here for today?
I don't have the case number by memory.
Did you create a report at the time of your investigation?
Yes, ma'am.
Would it help you refresh your memory if you had a copy of that?
Yes, ma'am.
All right, can you take a look at that for me?
Okay.
Do you recognize that?
Yes, ma'am.
Is it a fair and accurate depiction of the report that you created at the time of the investigation?
Yes, ma'am.
And would it help you refresh your memory if you were able to review it?
Yes, ma'am.
Okay, so you can not read from it, just refresh memory. What was the SAPD case number associated with the call?
The SAPD case number was 22108229.
All right, and so what were your duties or how did you become involved in the investigation in that case number?
I received a phone call the morning of that, the day of that incident, and was advised if I could come in and help conduct surveillance at different locations.
Okay, and at that time back in May of 2022, were you assigned to the repeat offenders program?
Yes, ma'am.
Okay, and the repeat offenders program, is that under the covert unit?
Yeah, it's still the same duties, just a different name.
Okay, and so you would still be operating in plain clothes and unmarked vehicles, is that correct?
Yes, ma'am.
All right, and when you were called in, what were you assigned to assist with?
We were assigned to assist with trying to track down an individual who we believe may have been involved in an incident overnight.
Okay, when you say we, who else were you working with at the time?
Other covert detectives.
Okay, was Detective Joe Rios one of the other detectives you were working on?
Yes, ma'am.
Okay, can you kind of describe to us the process, if you know, of checking locations where the suspect may have been staying?
There's different ways that sometimes we obtain information, whether it be old reports, traffic citations they may receive, vehicle registrations, things of that sort, to try to find the most recent address maybe somebody might be staying in.
Okay, in this case, were you in charge of obtaining any license plate record or any records relating to the pinging of the defendant's phone?
No,
Okay, and so did you have any knowledge of the findings of that information if someone else did it?
no.
Okay, and so how did you end up at the 12607 Judson Road, San Antonio, Texas 78233 location?
So I received information via the radio from one of my team members, Detective Joe Rios, that the address on Judson Road was address of interest, and that we should probably go get eyes on that location.
Okay, would you have considered yourself the lead, like, I in this case?
Yeah, so once I made the location, I took what we call in our unit the eye on a location that we thought potentially that the target of our investigation or our surveillance might be at. So I took the lead on that position, the eye, and coordinated the other detectives and patrol officers that day.
Okay. Do you recall where your vehicle was positioned in relation to the specific apartment?
Yes.
Where was that?
So I had backed into a spot. Yeah, I don't know if you have a map I could show you, but sure.
This has been entered into evidence, obviously, exhibit P6. It's a very zoomed out version.
And if it's easier for the witness to step down, the court is fine with that.
Can you see that or do you need?
Yes, yes, ma'am. I'm familiar with it now that I can see it.
Okay, and on state exhibit P6, are you able to see where you parked or no?
I cannot see the individual spots, but I can point at the area where I had positioned my vehicle.
All right, that would be fine. Go ahead and step down to some point.
Okay, so this is the location of the apartments. This is would be Judson Road. So as I entered into the complex, the first building on the right, there is a trash compactor on the south end of this parking lot. I took a position probably maybe 2 spots north of that trash compactor. And like I mentioned earlier, I backed into that spot so that I could observe the breezeway and the general vicinity of that apartment building and that breezeway.
Thank you. You can take this. All right, and so while you were conducting surveillance at that location, what did you observe?
I observed, people coming and going. I could see an apartment directly in front of me with a balcony on the first floor. I don't recall the second or third floor or how many floors there were. I think the information that we had received, or I had received from Detective Rios or on the radio that our interest should be that apartment or that breezeway.
Okay, and did you observe the defendant exit that apartment?
Yes, so that day I observed him come out to the balcony, but not outside the front door. And a few moments or minutes later, I observed him come out of the door into the breezeway. And then he attempted to go back into the apartment. And I think he might have been accidentally locked out, or he had a knock on the door to go back in.
And then subsequently later, he ended up coming out to the parking lot away from that specific unit, far enough away where we could safely try to detain him.
Okay. And so when you felt that he was taking enough distance away from detention, then what did you do?
So typically we wait for the person to get away from the door just in case if he wants to run, or sometimes we have family members that will come out. So we want to get him away and use the element of surprise so that it's safe for him and it's safe for us. So we don't get into a situation where it could turn into something bad.
Okay. Then once you had eyes on him, was this relayed to the other detectives that you were working with?
Yes, I was advising them that I had a positive ID on him based on some photos that I had received. And I was confident that this was the target that we were looking for.
Okay, and then once you called it out, what happened?
So what I was doing is I was positioning officers on the back end of the apartment complex, or I'm sorry, I misspoke, the building that I pointed out in the picture. So whenever he came away from that door and into the parking lot, when we approached him, they would cut off the doorway. That way he couldn't run back to the door, and had them approach from that way. So when he came out to the parking lot, I took the opportunity to have the marked patrol units pull in, and they're in fully marked uniforms and patrol cars to take him into custody there in the parking lot.
Okay, so he was taken into custody?
Yes,
And was he further identified once he was taken into custody?
yes,
Okay, were you equipped with a body worn camera during this time?
yes, ma'am.
And were you confident to operate it?
Yes, ma'am.
I'm showing you what's been marked as State's Exhibit R7. Do you recognize that?
Yes, ma'am.
What is it?
It's a CD with my name on it. I initialed and wrote my badge number on there.
Have you reviewed it?
Yes, I have.
Was it a fair and accurate depiction of the events as they unfolded on the date?
Yes, ma'am.
At this time, state tenders State Exhibit R7 to defense for inspection and offers
No objection.
All right, and that's R,
7.
all right, R7 is admitted for this hearing without objection.
Permission to publish, Your Honor.
Granted.
All right, and so at this time,
For myself and Manny can cut him off to the door right now.
State Exhibit R7, that is, what time did your body worn camera start?
It looks like approximately 11:13.
And were you able to see where you were positioned at this time?
I can see inside my vehicle. Are you talking about what I'm observing throughout the windshield, to the front of my windshield?
Let me just ask a different question.
Sure.
Are you able to tell, were you in that reverse position that you previously explained?
Yes.
Okay.
Together. F3, go ahead. Cameras.
Hold on, guys, hold on. He's walking back, guys. Hold what you got.
We're rolling Hayden back with the uniforms. Lopez is gonna call. He's in the best spot.
He's back in the door, guys, back in the door.
Red polo shirt, red polo shirt. Babysitting back with the uniforms, we're on the way.
Okay, I'm gonna fast forward to 20 minutes and 14 seconds. And so you're conducting surveillance for this entire time, and that you're in the vehicle, is that correct?
Yes, ma'am. All right, I have eyes on the female. She is on the balcony. She's looking around. She's wearing a black shirt, gray shorts. Back inside the apartment.
And I'm gonna pause you to give it R7, the female that you're referring to, is she associated with the apartment that the defendant was staying at?
Yes, ma'am.
I fast forwarded, so you give it R7 to 53 minutes and 11. And so
White Mitsubishi, yes,
this entire time, have you been conducting surveillance at the location?
yes. Just pulling up with a handicap plate.
Maybe heard that?
Possibly. All right, guys, he's coming out. He's coming out. All right, street crimes, let's go.
No weapons, sorry.
And does that show the apprehension of the defendant?
Yes.
We have the witness stand.
All right, defense.
No question.
All right, thank you. If you'll leave the microphone. State, call your next witness.
The state calls Detective, Scott.
All right, if you can raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. And if you'll place that square microphone on your lapel or somewhere, it's for the court reporter to hear.
Yes, ma'am.
Thank you. You may be seated.
Thank you, ma'am.
All right, state.
Detective Scott, how are you currently employed?
Yes, ma'am. I'm a detective with the San Antonio Police Department on the Fusion Unit.
And are you certified peace officer?
Yes, ma'am.
How long have you been employed with the San Antonio Police Department?
13 going on 14 years, ma'am.
And what are your duties as a detective, with Fusion?
Right now is going to be intelligence, gathering, disseminating information. Also, we also have a lot of different partners that we work from federal to state agencies, and we just do a lot of sharing of information, collaborative work, and also a lot of task force, just oversight and monitoring and managing certain individuals that are a part of those initiatives.
Back in May of 2022, were you employed with the San Antonio Police Department?
Yes, ma'am.
Were you a detective at that time?
Yes, ma'am.
And what unit were you in?
Homicide unit.
And what were your duties with the homicide unit?
It's going to be investigating cases, dealing with our case responsibilities of felony and misdemeanor cases involving guns or sometimes assaults.
Okay. Do you recall the SAPD case number that was associated with the case that we're here for today?
Yes, ma'am. I do recall the case, but not the case number itself.
Okay. Did you write a report at the time of your involvement in the case?
Yes, ma'am, I did.
And would it help you to refresh your memory if you were able to review a copy of that?
Yes, ma'am. Thank you.
Can you take a look at that?
Yes, ma'am.
Do you recognize that?
Yes, ma'am. This is my police report.
Okay, and you authored it,
Yes, ma'am.
and it's a very accurate depiction of your report?
Yes, ma'am.
Alright. What is the SAPD case number that was associated with the case that was your report today?
Yes, ma'am. It's going to be SAPD 2210-8229.
Do you recall how you were assigned to assist in the investigation?
Yes, ma'am. Normally a detective will say, hey, I got a hot case coming in. Can someone assist? Or they have a case that happens over the night that we get assigned to, and pretty much ask around the office, hey, can anybody assist me with warrants or this or that, whatever the request might be. This one here was a request to write a search warrant, and that was my dealing in this case.
How did you receive the address of interest, if you recall?
I was, on this case, I believe I was given the case, given the address by the handling investigator.
Did you ever prior to writing the search warrant, did you ever make the scene, the location of 12607 Judson Road, apartment 1101?
No, ma'am, I did not make the location before writing the search warrant.
Okay. And so in the process of completing the search warrant, did you receive information from detectives that were on scene and the handling detective?
I received information from officers on scene and not the handling investigator.
Okay. Did you conduct any additional research for the substance of the warrant?
Yes, ma'am, using open source information, just Google Maps, Google Earth, and just trying to get a depict of the location, and also confirming those details with officers on scene of the location.
At the time that you wrote the search warrant, did you have any knowledge of any investigators obtaining real-time cell phone tracking location data or license plate reader data?
I had no details of the case besides the offense and the needing of a search warrant, so I had no information of ALPR or the cell phone information.
Okay, and so it's fair to say you did not rely on that information when drafting the search warrant, is that correct?
That is correct.
And so did you complete the search warrant and obtain a signature from a judge?
That is correct.
Showing you what has been marked as State Exhibit R8. Can you take a look at that and tell me if you recognize it?
Yes, ma'am. This is the search warrant that I would have wrote that day and got signed by the judge.
Okay, and
Yes,
that's a fair and accurate copy of the document.
Yes, ma'am.
At this time, the state offers State Exhibit R8 and tendering the defense for inspection.
All right, State's Exhibits R8 is admitted without objection for the purposes of this hearing.
We pass the witness, Your Honor.
All right, defense.
Morning, Detective Scott.
Good morning, sir.
So you were assigned to an investigation on May 22nd, 2022, correct?
I was assigned to assist.
To assist. And
Yes, sir.
it's fair to say that your role was limited to essentially drafting this affidavit for the search warrant and getting the search warrant signed by a judge.
That is correct, sir.
Okay. And the investigation was for an officer involved, correct?
Yes, sir.
Okay. And Tyler Ashbaugh was identified as a suspect.
I did not even see the suspect, so I guess that's the case. Yes, sir. I just got the search warrant.
So Tyler Ashbaugh doesn't ring a bell to you?
As far as the name, only because of the reports, yes, sir. But as far as any other details, I was just tasked with the search warrant, sir.
Have you had a chance to review your affidavit for the search warrant?
Just today, yes, sir.
Okay. And you wrote in that affidavit that the actor's identity was provided to officers and his known address is the one listed above, correct?
Yes, sir. That's
And you listed the address as 12607 Judson Road, apartment 1101, San Antonio, Texas 78233.
I believe so. Yes, sir. I don't.
And is it fair to say that that's the only line in the affidavit that relates to how this apartment unit was identified?
For the search warrant, yes, sir.
Yes, just that it was his known address. And there's no other details to say how this became known as his address.
In my original report, I believe the person told me that I guess there was a vehicle that was ran and that I guess the person who was driving the vehicle was, I guess, the defendant in this case. But as far as in the search warrant, that's what I put, yes, sir.
Okay, so there's no other information in the search warrant that states how this specific apartment unit was identified as the address searched, correct? Just that it says his known address.
His known address, yes, sir.
Okay. And so you didn't conduct an investigation to say, this is his known address. This was information that was provided to you, correct?
Based on the handling investigators' research, yes, sir.
Okay. And so is that all that was provided to you? Is that they just said this is his known address?
Based on their research, based on their investigative actions, yes, sir. They told me that information, and also I put a little, I guess, a couple lines in my report on how they were able to get to that information of using the vehicle registration and going over to, I believe, the parent's address and verifying some details and going that route. And that's how it became known that that was the defendant's address.
You stated speaking with other individuals to determine the address. Is that what you said? That the officers spoke with other individuals?
I believe they spoke with other individuals. I may have misspoken, but I believe, not trying to read off my report, but I believe they actually made the location and talked to people and did a little field work to be able to determine that was the, I guess, vehicle being used by the defendant.
Say made the location and talked to people.
Yes,
What
sir.
location are you talking about?
Can I use my report to refresh my memory? Thank you, sir.
Feel free to read the entire report.
Yes, sir. On my report, it doesn't have that address, sir, of what locations detectives made to do their field investigative work, sir.
Your report states that you were provided the address of 12607 Benson Road Park, 1101, correct?
Yes, sir. That's the address that I was provided for the warrant. Yes, sir.
But it does not state how they located that apartment, correct?
No, sir, not in my report. I don't know how they got those
Okay.
details.
So you don't know how they got that location, it was just provided to you.
That's correct, sir.
So I know that you testified a little bit earlier that there may have been some other information about how this address was located. Are you correcting that prior statement now and saying that there was no other information provided to you as far as how that location was identified?
So I can be clear, they did investigative work where they went to one address, but I don't know those different addresses. That's based on their research and their information gathering that led them to this location or getting the information for this location. And that's the location that I was provided to do the search warrant for. I don't know how they got the links, but I got the address from the handling investigator who assigned me to do just the task of handling the search warrant.
So they provided you with this address,
Yes, sir.
but you don't know how they identified that address.
No, sir.
Okay.
No further question.
All right, you need to step down. Make sure you leave the microphone
Yes, ma'am.
behind, the square microphone.
Yes, ma'am. I got you.
Okay, thank you.
Absolutely.
State, call your next witness.
State rest.
Oh, is it? Yes, ma'am.
All right, defense, any witnesses?
No, defense rests.
All right, court will hear argument.
Judge, if I could just have one second.
Sure.
Judge, I guess if it's defense's motion, I believe that their argument is.
Yes.
That's fine, Judge. Okay, Judge, as I stated earlier, we're seeking to exclude all the fruits and all the evidence that was located based on the search of Tyler Ashbaugh's apartment unit. Also that, and that the attenuation of the taint from that illegal search was not great enough from when he was actually taken into custody and then immediately transported to the San Antonio Police Department to give that statement. And so, as you heard, Judge.
Well, let me ask you this, with regards to the statement that you're saying that he gave,
Yes.
was he not taken into custody because he had some sort of outstanding traffic warrant or some type of warrant?
Well, so yes, if you let me start from the beginning, I can kind of work my way to
All right.
that one as the last point. I think hopefully it'll make sense.
Okay,
So obviously, I believe that it's undisputed, there was no warrant in this case. The state could not produce a warrant. There was no warrant used to get Tyler's real-time cell site location information. And so this search is illegal for two reasons, Judge. Because they should have gotten a warrant and they did not get a warrant. That's under the Sims case, Texas Court of Criminal Appeals. It states that you decide if on a case-by-case basis, when real-time cell site location information is obtained without a warrant, and you're deciding if there was enough that was obtained to where Mr. Ashbaugh actually had a reasonable expectation of privacy in his real-time movements, which I would argue he does, especially when he's in his apartment complex at the place he lives. If they're tracking him where he lives. I don't know how anybody wouldn't have a reasonable expectation of privacy from this. And that's also based on the Carpenter case, Judge, Supreme Court case. And that looked at historical cell site location information, but they ruled that the third party doctrine does not apply, where, okay, a cell carrier just obtains your data, therefore you have no reasonable expectation because a cell carrier has it anyways and you're giving it to them. They stated that it's essentially a tracking device, and then if you get enough information, it amounts to a search. You have a reasonable expectation of privacy in your movements, and you're not just giving that up because a third party obtains that data. And the same idea, it says, applies to this, but and by this I mean real-time cell site location information. So you're deciding on a case-by-case basis, does the amount of data that they receive violate his Fourth Amendment constitutional rights because they obtain an amount of data and yet reasonable expectation of privacy in his real-time movements, Judge. And in Sims, this was a case where Texas Court of Criminal Appeals, where a suspect was tracked from Texas to Oklahoma, but they only pinged his, and I believe it was Oklahoma police that eventually took him into custody, but he was only pinged 5 times. You heard in this case that Tyler was pinged 27 times. Once again, they should have done that with a warrant. Alternatively, they did not even have probable cause to do the real-time cell site location information. You heard from Detective Tudor in his statement, in his testimony today, that he told Mr. Escobar, Tatiana's father, that he didn't have enough information to know what was going on. Every witness agreed that Tyler was taken into custody due to his municipal court traffic warrant. There was no arrest warrant for aggravated assault on a public servant. He was taken into custody on that so that they could continue investigating. If they had probable cause, they could have gotten an arrest warrant for Tyler. But all of those statements and all of that indicates that they did not feel at this point that they even had probable cause to arrest Tyler. So they had to do it the strategic way of trying to take him in on a municipal court warrant and then interview him. And then also, Judge, in relation to the automatic license plate reader information. If you look on that exhibit, the amount of automatic license plate reader data that they received was over a year's worth of tracking data. It says first seen February 2nd, 2021, last seen May 13th, 2022. So they have gathered so much data on his automatic license plate reader. I think this is an relatively undeveloped area of case law, but I would argue that the same reasoning in Sims and in Carpenter apply to this. What you're doing is you're not just giving up your reasonable expectation of privacy because you're driving your vehicle. You can't expect that somebody's just going to be tracking your location at all times. And that maybe if they had done a little bit of license plate reader data, that might have been okay. But they got over a year's worth of license plate data, also without a warrant, to track him to this location. And Detective Rios's statement, Judge, he only lists the cell site location information. He doesn't even mention this license plate reader data. And now he comes in here, and this contradicts what his report is saying, is that, oh, actually, with the license plate reader data that we didn't use to locate his information. Whereas he states in his report, we got his real-time cell phone tracking information, and the tracking information is what led us to the apartment. Detective Tudor was trying to obtain this apartment unit by calling individuals. He knew that these people, the relatives of Tyler, were telling him that all they knew was the apartment complex. Nobody could provide a specific unit. By the time he tries to inform the other detectives, hey, this is the unit, well, they're already like 3 steps ahead of him. They already know the unit that Tyler is in because they've utilized ALPR records and this cell site location information. And we were not even produced any application documents that were required to do this. Mr. Rios, I forgot his title, but Mr. Rios, he stated that this is a process where you can need to get permission from the cell carrier. It's not just something that's automatic, even though he's never been denied. But you don't just get to do it at any time you want. There is a process for applying. There are no documents on that. He's the one that that all of this is given to. His email is the address that's in all of these documents. And then furthermore, Judge, now we're getting to, okay, that is the only reason that they were able to locate his apartment warrant. Detective Tudor doesn't have anything in his report regarding any water bill or anything like this. Nobody has anything like that. The only reason that anybody stated in any report that they located it is because they did the cell site information, and then based on that, they knew that this is the location of the report, and then they did covert surveillance, took Tyler into custody. And a magistrate was prevented from knowing that this is a factor that was used in apprehending Tyler. All the magistrate had to go off of is that this is his known address. And Judge, that is at the minimum, a reckless disregard for the truth, which under Franks v. Delaware, that part of the warrant should be excluded. I'd appreciate counsel not laughing at during my arguments. I can hear that.
I did not do that.
But you scoffed.
I
So,
was clearing my throat, so.
okay, all right,
And so, I have a separate apology from you now.
okay. No. And so, Judge, this apartment search warrant was based on information that was not included in the warrant. This is at a bare minimum, a reckless disregard for the truth. And that means that if there's any false information or information that's a reckless disregard for the truth, that portion of the warrant is excluded. And so we have his apartment unit. That is the only, if that is taken out, the identity of the apartment, then none of this warrant stands. There is no warrant because that is the only reason that they say this is located. They say this is his known apartment. Not one single witness said this is his apartment. And so the case law states that a search warrant that is based on that is based on an illegal search is also illegal. And so you have it for that reason. You also have it under the Franks v. Delaware. That doctrine, Judge. And so in summary, there's three avenues to suppress the apartment search warrant. There's no PC pre-emergency tracking. If there was PC, they needed a warrant, which they didn't get due to the amount of data they collected. And there was false information in this warrant. I'm not stating that Detective Scott is trying to intentionally lie, but clearly all he did was receive this information from somebody else, and they did not tell him the full picture. This is not Tyler's known apartment if nobody can even identify it. And for those reasons, Judge, I would ask that you grant the motion to suppress, exclude any of the evidence found in Tyler's apartment, unit 1101, and then also, as the only reason they were able to locate him and take him into custody is due to that warrant. The arrest itself is illegal, and there's no attenuation of the taint before his statement, and that statement is also illegal and should be suppressed, Judge.
All right, Spade.
Judge, regarding the license plate information, I mean, that is well established law. If somebody enters a motor vehicle and is driving around the state of Texas, they have no reasonable expectation of privacy in that data. And so that argument just fails on all fronts. But moving on to the real-time tracking of the defendant's phone, my response under the Sims v. State case, and that site is 569 Southwest 3rd 634. The inquiry that the court looked at there was whether the government searched or seized enough information that it violated a legitimate expectation of privacy. In that case, the court found that the appellant in the case did not have a legitimate expectation of privacy and his physical movements or location as reflected in less than 3 hours of real-time cell site location information obtained by the police. And so while it was 27 pings in total, as told by the testimony of Detective Rios, I think he testified that it was less than 12 from the time that the defendant was taken into custody, and that was less than 2 hours. I believe that's what he testified to. So I believe that they started the surveillance around 10 a.m. and the defendant was taken into custody around noon. Now, even if the court does find that a search occurred, I think my argument is defense can't have it both ways. They can't say that's not his known address and then argue that he has a reasonable expectation of privacy there. And so I've already stated about the reasonable expectation of privacy and the license plate, but also regarding the cell site location data, there's no implied warrant requirement, and that is under Holder v. State. The site to that case is 595 Southwest 3rd, 691. And that case states that a warrant is generally needed under the Fourth Amendment to access that information, but there's no implied warrant requirement. And so the inquiry is whether the search was reasonable under the totality of the circumstances. Here, Detective Rios did testify to the circumstances which led to them going that route, which was that 2 officers were fired upon totally unprovoked. The officers did return fire. At that point, they did not know whether the suspect was hit and needed medical attention and just safety for the general public. Further, so my argument also under Carpenter v. State would be that no warrant was required due to those exigent circumstances. Further, Detective Rios testified that real-time location data did not even lead them to the apartment complex. That's not what was relied upon. Obviously, his report is not in evidence, but I specifically asked him in the portion of his report where he was referring to the tracking information, what was he relying upon? And he said the license plate data. Now, for the search warrant for the apartment, obviously there's a good faith exception in that the evidence was obtained by a law enforcement officer that was acting in objective good faith, relying upon a warrant that was issued. And should the court find issue with the warrant that was executed on the apartment, there is also an independent source exception in that Detective Tudor testified to all of the information. He received specific instructions as to where the apartment was located. It was across from a compactor on the first floor, and it was the first apartment to the left. And so these are facts that Detective Tudor did also testify that that information was relayed to covert. And so that is information that they would have known from the get-go. Regarding the Franks, the relevant inquiry there is whether the person that swore to the affidavit swore to it with knowledge that the information was false or with reckless disregard for the truth. Detective Scott testified that he, was relayed that information from the people on scene. And so I believe that that argument fails.
All right.
In sum, there was no illegality on the part of SAPD regarding the cell site location specifically. The witness testified that none of those latitudes, longitudes led them to that specific apartment or even the apartment complex.
All right, defense, it's your motion. I'll give you final argument or response to the state's argument if you want to respond.
Just briefly, Judge, I think I've made all my points in my first argument, but I guess I don't really understand the argument that I can't have it both ways because it's not his known address and he would have a reasonable expectation, and that those things are not related, Judge. He has a reasonable expectation of his real-time cell site location information if you determine that SAPD got enough information to where it was it did violate the Fourth Amendment, and he does have a reasonable expectation of privacy in that. To say that it is his known address when not a single witness knew what the address was, that is false or a reckless disregard for the truth. And when the only way that the warrant identifies the place to be searched is to just say, this is what we're searching, apartment 1101, and we're searching it because it is this person's known address. this magistrate was prevented, and I think that they would probably want to know, as a judge, that the reason, part of the reason this was located was because of ALPR data and real-time cell site location information without a warrant. They might have started asking questions at that point. Instead, all they read is this is his known address, and so they don't have to ask any more questions about that. And that is a lot of information that's left out of this warrant. That is enough information that's left out of this warrant, and it's false information, at the very minimum, a reckless disregard for the truth, Judge.
All right, and then the next issue is with regards to spousal privilege. Does anybody want to address that, section B of 504?
Your Honor, I'd like to address that.
Sure.
Your Honor, the court points out to 504B4B, which applies an exception for matters that occur before the marriage.
Mhm.
It's our position that a common law marriage exists between Mr. Ashbaugh and his wife at the time of the alleged offense.
No evidence has been presented that a common law marriage existed.
Therefore, we request a hearing outside the presence of the jury to determine whether a common law marriage existed that would preclude the state from calling Mrs. Ashbaugh as a witness. I would cite two cases, both from the Criminal Court of Appeals, Bush v. State, 159 Text Crim 43. In a prosecution for aggravated assault, if the relationship between the defendant and state witness constitutes common law marriage, witness was disqualified as witness for state, and the disqualification could not be waived. Another case from the Criminal Court of Appeals, Hightower v. State, 629 Southwest 2nd 920. A party claiming existence of informal marriage has the burden of proof by a preponderance of the evidence. So we would request a hearing. And
But didn't you all state, and if I'm wrong, correct me. Didn't you all state that this was his girlfriend and later they got married, and your sole argument was, co-counsel's sole argument was that, one, the court was reviewing the wrong section about confidentiality. He was focused on the privilege, and that it didn't matter. Your co-counsel's argument was it didn't matter if they were married then or married now. The fact that your co-counsel's argument was that all that matters is that they're currently married, and because they're currently married, it doesn't matter that information was told to the spouse was given when they were just girlfriend. That was your co-counsel's argument. So are you all changing the argument now?
Your Honor, I think co-counsel may have misread the statute, and because of that, we did not feel the need to rely on the common law marriage as an avenue to have to invoke this privilege. However, we would ask that Tyler's wife be given the chance to testify as to whether the common law marriage did exist, which we believe we can meet, and it's only by preponderance of the evidence.
Is she here right now?
No, Your
Oh, so this is what we're gonna do. We're gonna stay right here. Someone pick up the phone right now and ask her to be here. She's under subpoena.
And Judge, at this point, I just want to point out to the court that as an officer of the court, Mr. Navy did state when he urged his motion that at the time, that was the defendant's girlfriend and they were living together. There was no mention about a wife. And so at this point, I am going to request that Tatiana Ashbaugh be appointed an attorney.
All right, so someone call her and tell her to come down now. Oh, you can remain in the courtroom when you call her, sir. All right, so when will she be here?
Judge, my understanding is she's in Helotes, does not have childcare, but she can try to be here with the child as possible.
Okay. All right, we will be back at 1:30.
We do have one final motion, Judge.
Oh, and I'm sorry. What is your final motion?
That motion is the motion to require the state to elect which paragraph on count 3 that they will rely on for a conviction.
All right, so that motion, state any response.
My response is that there are alternative legal theories, which is clearly authorized by the law, and so I do not believe that I need to elect as to which paragraph I'm going.
All right, the defense's motion to the, yes,
I'm sorry, can I make an argument? Judge?
yes. I've read the case law, but you can make an argument.
Okay. Okay, well, it sounds like the court knows, but I'll make my.
No,
argument.
I mean, I'll hear argument. I always have an open mind
Okay, I appreciate it. Judge.
because maybe the law, there's a different take on it.
Okay, so count 3 contains paragraph A and B. And I believe that the case law is clear that the state can only have one conviction per count. They cannot get 2 convictions per count. So if there are multiple paragraphs, they can only have 1 conviction. And so paragraph A and B do not simply state different manner and means of committing the same offense. This is not different manner and means, let's say, of an assault, where it can be like by the foot, by the hand, pushing, hair grabbing, something like that. Each of these paragraphs alleges a distinct and separate offense. They have different mens rea in there. You have one that's knowingly shooting at and in the direction of individuals, and that's it. The other one is knowingly shooting at and in the direction of the vehicle, and the defendant was reckless as to whether or not the vehicle was occupied by failing to make adequate inspection regarding the presence therein. And so both of these subsections specifically define conduct in ways that require distinct and separate acts with distinct and separate mens rea. So they have different mens rea, different actus rea. In the Go case, NGO v. State 175 Southwest 3rd, 738, Texas Court of Criminal Appeals 2005. Something very similar was discussed in regard to a credit card abuse case. They were all part of the same statute where there was different types of credit card abuse that were alleged. So you had receiving a card from somebody else or using a card that was from somebody else, and the court said that violated the defendant's right to a unanimous verdict. Because if we have paragraph A and B and there's only 1 conviction, and we don't know which one the jurors agree upon, then there's the argument that this is a non-unanimous verdict. Because there's only 1 conviction, and so we don't know if 9 people think there's shooting at the direction of a vehicle and just being reckless, and we don't know if there's other people that could be thinking that they believe beyond a reasonable doubt with the other method. But I would disagree that these are not simply different manner and means of the same offense. They are distinct and separate offenses. And the case law does say you can have distinct and separate offenses that are under the same portion of a statute.
Okay, all right, defense's motion is denied. With regards to the motion to suppress, is denied. With regards to the spousal privilege defense, you're now saying that they were in a common law marriage, is that correct?
Yes, Your Honor.
All right, then I think it would probably be appropriate to have an attorney appointed to represent her. Do you have any objections, defense?
There you are.
State?
No.
Mr. Porter? Are you available to represent someone as a witness? Brief witness with regards to common law marriage?
Yes.
All right, so she will be here at 1:30 if you're able to have a discussion with her before then. And counsels, you'll need to give, if we're off the record, if you'll give Mr. Porter her contact information so that he can speak with her?
Sure.
All right. I'm sorry, back on the record. Does anybody have any objection to Mr. Porter being appointed to represent